All right, so the session is now being recorded. So as I said, welcome to the first of will be a series of 4 webinars taking a look at estate planning issues from a financial advisory perspective. We're very privileged today to have Sumita Paul, who is an expert in this space. She works for Guardian Trust, Perpetual Guardian, who are probably one of the leading proponents of estate planning issues or estate planning services in New Zealand. The session today will go for probably run for about 45-50 minutes, and there'll be a little bit of time at the end for questions if they're not raised during the session. Okay, so I'm going to hand over the speaking rights to Sumita. Sumita, good morning. Can you hear me?
Yes. Good morning, everybody. Thank you, David.
Okay, I'll just quickly hand over presentation rights to you.
Right.
And then you can share your screen with the audience.
Is that visible now?
Yes, that's good. We can see that. Thank you, Sumita. So, welcome, Sumita. Thank you for your time this morning, and thank you for the effort you're putting in to bring this stuff to our attention. I'll leave you to the presentation.
Oh, thank you, David. Thank you very much. And thank you, everybody, for joining in this forum. And thank you to NZFAA for the opportunity given to Perpetual Guardian to make this presentation in relation to red flags in your process, red flags that come up in your process of engaging with clients relating to estate planning. Before we begin, I would really like to kind of introduce who Perpetual Guardian is. We are a very, very fresh brand in the market. However, it is made up of 2 very old trustee companies, a lot of you might be familiar with, Guardian Trust and Perpetual Trust. The 2 companies came together under the ownership of Andrew Barnes earlier this year, and hence the new brand Perpetual Guardian, noting the fact that we are 2 companies coming together. We still maintain 2 separate entities because the trustee companies are created by statute of parliament, so we're still 2 separate entities legally. However, we work together and known as Perpetual Guardian. Just a couple of facts here about how long we have been in existence. We have client managers like myself and client advisors who are estate planning experts throughout the country, starting from Whangarei down to Dunedin. Today's presentation, we are, from what I understand, this is the focus is going to be to help you pick up red flags relating to estate planning needs as you go through the needs analysis process with your clients, or even a general chit chat or a review you have with your clients. General conversation, things might come up with you, which kind of alerts you to the fact that the client might need to talk to someone who is an expert in the field to ensure that their objectives are met, no matter what happens in the future to them or their spouse. As things happen upon death or even due to incapacity or things like that. So there is a range of questions around estate planning at the end you need to which will help you kind of identify the red flags as you go through the entire process. So before we look at specifics, let's talk about what your clients' goals are and what they ideally want to achieve when they come and meet and their advisor, which is yourself, and they're talking to you. Now, when they come and talk to you about their financial affairs, be it their insurance needs, their mortgage requirements, wealth management, the objective they have is they want you to give them a complete and comprehensive advice. They do realize, I do realize there are specialities. You might be specialized in risk, you might be specialized in mortgages, or you might be doing a combination of those. However, when you talk to them, they expect you to to understand the ramifications of what they're doing, and which might be connected to other parts of their comprehensive financial situation. They will want to have the full use of their assets during their lifetime. Obviously, they worked really hard to build what they have done, or they are ensuring that any risks that they have are protected by talking to you. So, you know, the assets they have built up are protected, or their loved ones are looked after. Of course, they will probably want their children or wider family to benefit after both them and their spouse are deceased, or even when one of them pass away, to ensure that the surviving partner and the rest of the family are protected. And even if some people don't have any family, they might have other objectives in mind. They might have philanthropic objectives. So they're coming in talking to you to ensure that their objectives are met with the advice you are giving. Now, your clients have options around the services and products, but they have chosen to come to you. They have the choice of going anywhere they want, and hence it is probably very important for you to ensure that the additional services you provide for your clients, or the referrals you give your clients, are ones that can work with you and understand what you're doing, and ensure your client is kind of, you can ring fence them by providing a complete package and ensuring that, you know, they are stay with you. Now, what don't your clients want? They will not want their family to lose any of their assets to a third party. In some ways, we call it like a creditor risk, or another party who might be outside, or the family, or probably a previous relationship which was not thought of at a future date, etc. They will not want to, or have their spouse or partner lose control of the assets upon their death, depending upon the situation they're in. They will not want their children's inheritance to be lost to them or by them after they receive it. So again, ways of protecting the inheritance for their children, or wealth transfer through generations. So what happens on the death of one party to the relationship when all the assets vest in the survivor? Now, these are situations you sometimes see, or we see, when there is a blended family or a second relationship, where sometimes transfer, leaving everything to a spouse, might not achieve what you originally want, taking into consideration children from a first relationship and children of a second relationship. There might be classes of beneficiary who might totally miss out on in their inheritance, which you might originally intend, or your client might originally intend to give to them, but in situations that can change after your death. I have a few examples. I will explain to them as we go ahead in the seminar. Now, that comes to, here we come to the question of, okay, what is estate planning then? How does that ensure that what your clients want is achieved? Estate planning, in a very brief summary way, is all about getting the right assets to the right beneficiaries at the right time. Now, you achieve that in different ways using different tools, but it's essentially the transfer of your wealth to the right people at the right time. Now, estate planning tools include wills, which all of you are probably familiar with, enduring powers of attorney, trusts, and even other asset ownership structures. It could be a company structure. It could be through insurance ownership, insurance products, and different types of ownerships. But what should you be looking for that will highlight a potential issue that will necessitate extra attention or advice? Those are the things that we are going to look for. or those are the red flags that you will find, which will want, after which you'll want to explore more information from the client, or refer them to, or alert them to the fact that they need to talk to as an estate planning expert to ensure that their structures are correct. Now we've got a poll coming here. Number one, this is just to get a sense of what you do on your day-to-day role.
Okay, so I'm going to, for those of you who haven't been this before, what I'll do is I will put up a poll. This particular question you can answer, you can tick more than one box. We'll put it up for a few seconds, get you to respond, and then we'll publish the results for the audience. So the question is, do you confirm with your clients during fact find if they have the below in place? So do you check with your clients to see if they've got a will, EPAs and trusts in place as part of your fact find process? So I'll give you 10 seconds. There's only about 57% have voted, 70%, so there's still about 10 people who haven't voted. 5, 4, 3, 2, 1. Okay, let's close the poll and publish the results. There was about 6 or 7 people that didn't vote on that one. Let's share the results, Sumita, and I'll so the results. Do you confirm with your clients during fact find if they have the below in place? 91% check with clients in relation to wills, 77% in relation to EPAs, and 86% in relation to trust. That's of the respondents. So there's about 24 respondents.
That is excellent, actually. That is very, very good. That just goes to show that, majority of you are aware of the implications and understand that the client needs to pay attention to these 3 documents. I should say this is the first time I'm doing a webinar where we have the live polls going, and I think it's fantastic just to know, to get a feel of what the audiences are or how much they're involved in the estate planning side of things.
The issue though really is in relation to the level of interrogation, isn't it? That
yes, that's exactly right. Which we will come to, because it can be quite tricky as well if you're not fully aware. I mean, it's important that the client is alerted to the fact that these documents are important, and then how much of that you discuss with them and talk to them about the implications is probably forums like these encourage you to explore more as well.
Exactly.
Right. Now, when completing needs analysis, these are a few red flags that can come up. We've just made a list of things in conversation, like we said in the beginning of the webinar. It could be a formalized needs analysis, or it could be a general chit chat, but these are the things that can raise a red flag when you talk to your clients. First, has your client been in a previous marriage or relationship? This can cause a lot of problems in terms of the assets they have and how it passes on in a will. Previous marriage or relationships, if under the, you might be aware, under the Relationship Act, if you have not settled, previous relationships might be able to claim on your will and your assets. So your client might think they're leaving everything to their current spouse and their children, but if there are matters that haven't been settled in previous relationships, they could have a claim on the estate, which can totally change the way they have arranged things in their will. Has there been a division of assets from a prior relationship? Exactly the same. The consequences can be the same as the first point we made. Is there a child from a previous relationship or marriage? Here again, there is a possibility of a claim if that child is not, or the benefit for that child is not recorded appropriately in the will. Concurrent relationships. It does happen, and this is one reason where sometimes our client advisors, when we meet with couples, I personally haven't had, but I've heard instances where we always give 2 business cards to the couple, and there have been situations where we received a call from one of them after hearing the consequences of what can happen, and talk to us about situations they might be in and the consequence of that to the current assets they might have. Another thing is, do any dependents have special needs? Do they have children who might be disabled, or other dependents or other family members who they're looking after who might continue to need assistance? Special provisions might need to be made for them. Another very important part is, where does your client reside, or where are they domiciled? They might have assets in New Zealand, but they might have dual citizenship, or they might be, depending upon where they reside, the 184 days rule IRD has. When they die, that will have an impact on the estate and the estate duties that might be prevalent in other jurisdictions. Does your client own or part own a business? Now, this is very crucial. Probably you would know more about the implications of these than us here in estate planning, because of the insurance risk covers and the mortgage advice you would be giving when they part own a business, the risk, the ownership, the transfer, the succession planning they might have, all those impact as well. And that needs to be reflected in their will, or even in their enduring power of attorney, to ensure that their wishes are carried out, or there are contingencies in place should they lose their capacity, they be disabled, or eventually should they die, the worst. Does your client own overseas assets? This is another fact find when you're listing their assets and liabilities. If they have overseas assets, that's another question, a red flag that was raised as to, okay, should something happen to them, how are those assets going to be transferred to the beneficiaries? Do they need to be liquidated? Or the way, whether New Zealand, whether they can be managed from New Zealand, or whether they have other people or nominees located in those foreign countries who might be acting on their behalf. And lastly, of course, important is, how is the property owned? As you would be advising them about the joint ownership and tenants in common, and the implication of that on their will and their inheritance plans. So before you get to the specific estate planning questions in your fact-find needs analysis, there are questions you ask which have estate planning implications. And these are a list of things that can be the ones that start off and have implications much more on, rather on the how relevant their current will is or not. Another few questions is, what previous professional advice has your clients taken in respect of estate planning? Now, you will find people saying they have a will, but it might be a will that they did probably 20 years ago, before they had children, or when they were in a relationship with their current partner, and later on they got married. And the fact that when you get married, your will is null and void is something that people might not realize. And they think they have a will, they realize they were the same person, they have children, and they said, oh, I've done a will and I've got the person in my will. But the fact that your will is null and void when you get married is something that people don't realize, and they do need to make another will to ensure that their spouse is looked after, and if they have children, their children are looked after, and the guardianship, and there are various aspects to think about.
That was one thing that surprised me. I think I mentioned to you earlier on, one thing that surprised me is that my following on from the seminar series, the will that I had in place, or have in place, was put together before my wife and I got married, and so now it's currently not valid. So I need to actually fix that up rather rapidly.
Exactly, and probably you wouldn't have appointed a guardians for your children there either.
Or
well, maybe you have.
We did originally, but
yes.
they're no longer valid because our will's no longer valid.
That's exactly right. There's nothing in place there. So those are the small things which, kind of raise a red flag and you realize, okay, the client do need to talk to someone who is in the area of estate planning. The next question is, like I said, a trustee, executor, or attorney for anyone else. You would know, as a trustee, there is a lot of responsibility and liability on that individual. Now, if they're a trustee and they've taken on that responsibility, what is the impact of that role? The next thing is executor. You know, you might have agreed to, or your client might have agreed to be an executor for a friend or a family member. The executorship role also comes with a lot of responsibility and liability, and a lot of activities that are required of a legal nature, which they require advice on. It's fine for them to take on that role, but to ensure that they do the right thing by their friend or their family who have appointed them, they need advice or ensure that they get the right advice to carry out their duties. That is quite important as well. And also acting as attorney for a person. Another thing is, your client likely to receive an inheritance. An inheritance from family which they receive, how they receive they can receive it into the normal bank account they own with their partner, and the implication of that, and how it can be kept separate as a separate property. Here again, property relationship comes into act. If your client receives an inheritance, they can keep it separate as their own property and deal with it through their will, or if it goes into a joint bank account, which is their normal expense, them and their partner use for their normal expenses and household living expenses, that inheritance becomes a relationship property, which eventually, should something happen to that relationship, will get split 50-50. So these are things that sometimes people just need to be aware of. They might, and then they are aware of the consequences of what they're doing. Again, is there unequal ownership of assets or liabilities within your client's relationship? We will go back, we will refer to these points as we go through the presentation, but these are, again, points of red flags. Are there extended family assets, holiday house, farms, businesses to be retained within the family? Now, those assets have to be dealt separately to the rest of your assets which you might be dealing with, because you have inherited those, and the intention might be to carry on holding those assets and passing it down to the next generation in the right form. So just a few questions that in your discussions that come up, you realize, okay, you can advise or just alert your client to the fact that, okay, that's good, you're having these things, but just bear in mind you might need some additional information to guide you through. Now, why is it important to identify red flags? The reason why it is, it's because the information conveyed to you by your clients could have a direct bearing on your recommendations for further estate planning needs, and also your recommendations on how they structure their risk product, the ownership of the risk product, or how they structure the loan they're borrowing, the liability, who holds the liability, in what form, the ownership of the property they're buying, and of course, if you're into investment planning, once again, how the investments are held, the ownership of the investments, who holds what, the implications should something happen to one of them. So again, coming back to the ownership, before we go into the implications or the acts that kind of oversee the administration of the wills and EPA and things like that, I would just like to go through another poll and ask you a couple of questions about the different acts that are that govern estate planning in New Zealand. So we've got another poll coming up, which I'm just going to go into the next screen, which will come up with a question, which is on the different acts we have covering estate planning.
Okay, so these are again, you can multi-tick, so you can tick more than one. So which of the following acts are you familiar with the provisions on and how they affect, particularly you as an advisor? So this is the legislation: the Family Protection Act, the Property Relationship Act, and the Testamentary Promises Act. These all obviously have a very important bearing on financial advice. I'll give another 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. And let's close the poll and look at the results. Okay, Sumita. The results: half of the audience who voted said that they're familiar with the provisions of the Family Protection Act. Almost 90% with the Property Relationship Act, and 29% with the Testamentary Promises Act. So, sort of a variation there.
Yes, excellent. I mean, it's really nice to see how everyone's aware of the Property Relationship Act, because that is quite critical, and it was a major change in 2002 when de facto relationships and civil union came on board, and people are fully aware of the implications of Property Relationship Act and the risk or the impact it has on the assets you accumulate. Thank you very much, everybody, for that response. It kind of gives me a good idea, so I can focus on the areas where the information may not be as much when you deal with your clients. Again, when an estate planning professional sits with a client giving them estate planning advice, the ownership of their assets are very, very critical because of the impact of these three acts. Now, so before I proceed into talking about the details of estate planning, I might just give you a brief description of the three laws that affect the administration of wills. Now, under New Zealand current legislation, the Family Protection Act, set in 1955, governs the protection of inheritance for children or close family. Now, the underlying rule is that everyone has a responsibility to ensure that their children are treated equally, and that children have a right to inherit from their parents. And it's not just children; it also extends to dependents. And a dependent is described as someone who might be reliant on you on financially, and you have been looking after them for a very long time, and after you're gone, you have a responsibility to provide for them. So the Family Protection Act, the classic case sometimes we see in our wills is mom and dad have 3 kids. 2 of them live very close. One's estranged or has just got separated from the family, got nothing to do, don't bring grandkids to their grandparents, have no relationship, do not respond to any kind of contact they try to make, no Christmas cards, no phone calls, nothing. Mom and dad are really, really unhappy with that kind of behavior, and they decide, no, this person does not deserve to inherit anything from us. He or she has been very, very rude in the way they have behaving, and they cannot understand why it is, and so they totally cut them out of their will and leave everything 50-50 to the 2 other kids who have been close to them. Yes, there is a reason why they have disinherited that person, or it might be even worse. Sometimes it could be because they have really hurt their family or hurt their parents and have done something really nasty and gone away estranged. And parents genuinely emotionally feel very strongly about not leaving any inheritance to that person and totally cut them out of the will. However, under the Family Protection Act, that estranged child can put a claim on the estate and say how, under the Family Protection Act, the parents had a responsibility of treating children equally, and that this person has not been treated equally and can put a claim. And what the parents intended happening might not happen. The court usually, majority of the cases we have seen, will change the final clause and ensure that the estranged party receives part of the inheritance.
Would that be on a, let's say you have 3 kids, and the parents chose to exclude one of those kids as a result of some of the circumstances you've described,
Yes.
would the court apportion a third of the estate to that child, or is it there are other factors that would influence the amount that
There
would
would be other. Yeah, no. It needn't. It might not be an outright third. It might be lesser than that actually. It will all depend upon what goes through the court. So essentially, it is contested in court. The papers go to the court, affidavits go, explanation notes go, and what we do in these scenarios is if we see somebody doing a will or that, we do warn them of the consequences of what they're doing. But sometimes it's genuinely there is a reason of why they're doing that. Then there are notes and they explain to us as to why it is being done, which is presented in court if it's contested. And then the judge makes a decision. Sometimes it's not 1/3, but they might receive only 10% of that estate based on the circumstances. But it's usually, in most cases, something is awarded. It might not be an outright 1/3, but something is awarded, and it could go up to 1/3 as well, depending upon what the arguments are and the situation is.
Right. Okay. Thanks.
Yeah, yes. So that is something to be aware of, so that they are aware that this is a risk that can happen if they have situations like that. Another thing we find is blended families. Blended families, which sometimes happen is you have a second marriage, you have first marriage, children from your first marriage, you enter into a second relationship probably later on in life, and depending upon how the will is made, everything might get transferred to the second wife or husband, and the intention might be to provide for children from the husband and wife have, let's say, 3 kids each. The second marriage, they make a will together. They leave everything to each other in the first instance, so that during their lifetime they have enough assets. But they might agree to, after both their lifetimes, leave everything equally to the 6 children. So 3 from the first marriage, 3 from the husband's side, and 3 from the wife's side. I have had a live example where the situation has been, they made similar wills. The husband died probably now almost around 15 years ago. The husband's children from the first marriage never got along with their stepmother and her children, and were a bit estranged. And sadly, it is not wrong, legally it's right. The wife decided to change the will because of their attitude, and she has totally written them out. And she's leaving everything to her children only. So the intention probably 15 years ago was to leave everything equally to the children, but she has chosen to do that. And the children from the first marriage might not have any right to her assets because they are quite age-wise. They are in the wife, or the person I'm talking about, is in her 80s now, and the children from her husband's kids are all probably in their 60s now. So there might not be a case. However, if you think about it, the original intention the husband had is not going to happen because of the changes that have been made, and his intention of treating all children equally will not be carried out because of the change that has happened. So various things. It could have been protected if he had structured his will slightly differently, or if it could have been protected if the ownership of the assets were held differently.
Could those children challenge that new will?
No, not really. It is it is her asset, and it's up to her how she distributes it, and they are not legally her children.
Right. So even though the source of her, at least part of her assets, was her husband's estate, to
Yes.
which those kids were entitled to some, potentially entitled under the Family Protection Act to some distribution.
Exactly.
Yeah.
Yes, that's correct, David. But they should have then put a claim on the estate when their father died. When their father died and left everything to, in this case, what happened is it's not, the will didn't leave everything to the wife, but all the assets were held in joint names.
Right. So
So when assets are held in joint names, when one person dies, everything
would
gets
already reverse
transferred
to
to
the
the
other.
other person,
Right.
yeah, by law of survivorship.
Right.
So she ended up owning everything, and yes, so those are situations you see, and you think, it could have been done differently if they had owned it, you know, in a different manner.
Yeah. There's a couple of
However,
questions come up. Um,
sure.
John Dryland's asked, is it under the FPA? Does the word child mean all children regardless of age or dependency? So I guess the
Yes.
question is, would all children, irrespective of whether they're dependents at the time of claim or the time of death, would they have the same entitlement as every other child? I guess something like
They they can claim under Family Protection Act. Yes, it doesn't matter whether they don't have to be dependent on the person who died at the time of their death. It is the treatment of whether they have been treated equally as the other, because a lot of the situations that we see currently is the clients, probably when they die, they're in their 80s,
Yep.
and the children are well into their 60s sometimes. However, I've had a situation where a claim was put on the estate under, I will come to that, under Family Protection, and the next one, the Testamentary Promises Act, because the oldest child, who was in her early 70s, was not happy with the way the chattels or the items, the jewelry and other items that the person owned, was gifted to among the family members.
Right.
So no, the age, it does not matter, or they don't have to be financially dependent either.
And I guess the key here as well is fair rather than equitable, doesn't it? So
Exactly,
yeah,
exactly,
yeah.
that's the case.
Okay. Then
That's
one
right.
further question.
Yes.
Neil's asked: is there a legal way that a client or a person who's putting their estate planning together can fully cut out estranged parties?
Estranged parties
I guess.
who may have a right to claim under these three laws.
Yes.
You can cut them out in your will. It can be a combination of how you own the assets and what you do with your will and trust. Or you can, when it comes to those situations, a trust sometimes is a real good answer, because the most robust instrument or document we have to protect assets in situations like these it eventually comes back to setting up a trust, family trust, or a trust under a deed which has very, very clear mandate on who the beneficiaries are and why they are. Because one thing you have to remember is all these laws are ones that govern the administration or of a will, of an estate. So people can claim on a will under these three laws. They cannot claim on a trust. So if there are estranged parties and if there are issues in the family, the best thing to do is then to have a trust, set up a trust, clearly denote who the beneficiaries are, transfer the assets that you want to protect in that for those beneficiaries into the trust, and that's it. And then what happens is when you die, you don't own those assets. It's already protected in the trust for the right people, and so people who contest your will not have anything to contest. The value of your estate will be very different, or the assets in your estate will be very different, because what really matters has already been protected under a trust. So yes, that would be one way we would recommend, depending upon
So proper ownership structures are quite important, and the look through provisions that are often, I think, from a tax and from a work and benefit point of view, are used to look through a trust. They don't apply to this legislation, so somebody couldn't say that this particular person has moved all his assets to this particular trust to avoid the provisions of the Family Protection Act or the Property Relationships Act.
Now, okay, coming to explaining that Property Relationship Act, yes, the trust, it's a totally different beast, as I can see a lot of majority of you are aware of the Property Relationship Act. That has a totally different impact on when you set up a trust. If you set up a trust with the sole purpose of avoiding dividing your assets under Property Relationship Act, it can be overturned, and like you said, the trust will not exist. It will be totally looked through, and the assets will be divided equally.
Right.
Because it's a different. Yeah. Yes. The Property Relationship Act has way more impact on a trust than a Family Protection Act.
Right. Okay.
Yes.
Sorry, I'm conscious of time, so I won't hold you up.
I'll quickly exactly. Now, I might just briefly explain the Law Reform or the Testamentary Promises Act, which seems to be the one where people aren't very much aware of. It's quite an interesting one, where this is an act which covers any, as the name says, promises the individual or the testator has made to somebody. Classic case is very old individual, asset rich but cash poor, has been looked after by a neighbor or a family member as a main caregiver, and has been taking care of this person for a few years. And what they usually and the promise made is usually, listen, I don't have enough to pay you for the services you're providing me. However, when I'm gone, I would really want you to have a gift of substantial amount, or I would like you to have part of this asset, because they are asset rich, but they might have a massive property, but they don't have cash to pay this person. Now, that promise needs to be validated in your will. Then, that should be flowing through. So in your will, you need to honor that promise, or say, I would like to leave a gift of 100,000 to this individual because of what they've done, or I leave my property to that person, or half of my property to this person. When that is not or carried out in a will, then the individual who has been promised has a right to claim on the estate under the Testamentary Promises Act. It's a very tricky one and a hard one to prove, because there has to be very clear proof to say that this person had actually made a promise to me. We have had situations where claims have been put on estates under Testamentary Promises Act, which have not been successful, and some have been, and we've come to an arrangement with the rest of the family and arranged it through a deed to readjust the distribution of the assets. So that's the Law Reform or Testamentary Promises Act. The Property Relationship Act, I don't think needs very much explanation. Everyone's aware of it, which was amended in 2002 to include de facto couples, marriage and civil union, where what says, if you have been in a relationship for more than 3 years, your partner has a right to 50% of your assets. So it is very important that the assets, the ownership of the assets, this is a classic reason why the inheritance, the question we discussed before, how it is held, whether it should be held in your own name and separately, or held jointly, or put into a property relationship account where it becomes tainted or blended and has to be divided. So I'm just going to move on to a couple of other slides before, because just bearing in mind the time. Briefly taking you through the Family Protection Act, we discussed dependents. Now, who is a dependent? Like I briefly said, it needn't be a child. It could be a family member who has been dependent on the client for financial needs, and who probably after their death continue to need that. So what are the legal and moral obligations? Again, I think I briefly discussed that when I was explaining the law. You do need to provide for them if they are a dependent, and make sure that they're provided for. And what are the remedies available? It can be done, again, through a trust, or even within a will. A trust can be created for an individual if they are dependent during their lifetime, and then after their lifetime it can be divided among other beneficiaries who you think are the final beneficiaries of that main estate. What is a relationship? This is a very tricky, it's still evolving actually. There are many factors they look at when defining what a relationship to qualify under your Property Relationship Act. They look at the duration, which we say the minimum 3 years, common residence, sexual relationships, financial support, joint ownership, children, how they interact, household work, and how they live together, public perception. Now, it is a combination of these factors that might be defined as a de facto relationship. So again, tricky. So as estate planning, when it comes to that, the biggest thing you think about parents is about thinking about the children as they grow up. The last thing they want is their children, the assets that they have built up for their children, getting divided into 50 half and going to someone who's had a short or 3-year relation or 5-year relationship with them. Now, I've got another poll, the last and final one, just talking about ownership structures, because this is quite critical when it comes to estate plans, about how they are owned. So just wanted to get a feel of how much you discuss with your clients when you comes to advising them on how this ownership structure on the assets.
Okay, so the poll is during the advice process at some stage, do you help the clients to understand the consequence of various ownership structures of whether it's a loan or investment or insurance on your client's estate? We'll run it a few seconds. See if we can get 100% voting this time. We've got, I'll give it another 5, 4, 3, 2, 1. Okay, we didn't unfortunately get 100%. We got 2. We've got a 90%. There's only 3 that didn't vote. Having technical issues causing them not to vote. So let's share the results. 96% do, 4% don't.
Yes.
So that's probably only 1 or 2 people don't for the purpose of this.
That's brilliant. I mean, that just shows the the professional advice you give, because it is so critical to achieving what they want to achieve. And so I'm not going to explain too much about asset ownership. I think seeing the response, 90% advising them, you're very well aware of the impact of joint ownership as tenants in common, and whether it is in a trust structure or a partnership, you would be advising your clients on how it should be owned. And again, the way you own it has an impact on how the assets get transferred upon death. As we discussed before, if it's held jointly, it gets transferred to the other person by law of survivorship. Your assets will not even fall into your will. It just automatically gets transferred to the other person. As tenants in common, each of the shares will pass through the will to whoever they want to, so that has an impact. Now, how will non-New Zealand assets be dealt with on death? One way is the will you set up in New Zealand can manage assets in other jurisdictions. However, sometimes we find that it is less expensive and easier if you have a will in other jurisdictions to abide by that, follow the rules there. Because what essentially happens is sometimes the New Zealand executor has to hire a legal firm or a lawyer representing the will in New Zealand, resealed in the foreign country, and then acted to get your assets liquidated, etc. So those are the things that your estate planning advisor can advise them on. Ownership structures for personal business, which I'm pretty sure I'm speaking to the converted, you would know much more about that than what we need to discuss here. Self-employed ownership structure for business. Again, succession planning is a very important part for self-employed people, which I'm sure most of your risk advisors would be dealing with when they talk to people, and the insurance products to cover those risks. I just have to say, an interesting example I had last time we presented was where an insurance policy was set up for succession planning. There were 2 partners. One partner died, and their insurance policy was in place to give money to the second partner to buy out the share from the first partner's wife. However, once the money was paid, the second partner decided, I'll keep the money. I don't want to buy the other share of the business. So the poor wife ended up with this half share of the business, which she didn't know how to run. And the other partner didn't kind of proceed to buy his share. I'm sorry. So yes, so having the right agreements in place and arrangements in place so that everything corresponds to each other is quite critical as well.
So in that case, was there no share purchase and sale agreement in place, or was there, or a what do they call the buy sell agreement? So there was no buy sell agreement in place,
I,
or
I'm guessing that, David, because this was an example that was given to us by one of the risk advisors when we were doing this presentation about that situation that came through.
right?
So probably they put the policy in place with the right ownership for the policy. However, it had to be supported by the buy-sell agreements. Obviously, that must not have been in place, otherwise it would have been a breach of an agreement.
Yeah.
So just how critical it is to link what you are doing to other legal documents and other aspects is absolutely critical for the right outcomes.
I think that highlights the need to make sure from an advice point of view, and particularly in the business risk space, that the I's are dotted and the T's are crossed. I know a lot of business risk advisors these days are sort of putting themselves up as project managers and actually managing the whole process, not just the insurance side of things, but all the legal documentation, making sure that it gets put into place as well as part of the overall program.
That's excellent. I mean, see, that's what your client needs. They need a comprehensive, full advice. They don't want to. It is, yeah, absolutely. That's the way to go. That's the professional advice you'd be giving them. So the whole thing's covered. All aspects are covered. Quickly touching on the liabilities of personal guarantees, joint and several debts on death, and things like that. Here, I just want to alert to the fact that the ownership of the asset versus ownership of the debt is quite critical as well. You might have an asset which might be held as tenants in common, where the half share goes through to each individual. Should something happen, it will go through their estate. But the loan might be held in joint names. So when an asset is held in, or properties held in tenants in common, and a husband or a wife dies, that half share will go into the wife's estate if she dies first. But the loan, because it's in joint names, might go into the husband's name and become a huge liability for that person. So just things to cover to ensure that if that is done, the right reason or the right risk policies are there to cover that situation. Again, alerting the fact if your client is a director, an executor, trustee, or an attorney, they have legal responsibilities and liabilities on them which they need to be aware of. And should something happen to them or they become incapable while in that role, what contingencies are in place to ensure that that role is carried on and they are free of the liabilities that they may have.
Can I go back to that? Sorry, the personal guarantee one.
Sorry?
The personal guarantee comment you made. In the event of somebody's death, does that personal guarantee move with the estate, or does it die? Does it expire?
The personal guarantee dies because the individual dies. Yes. However, if you're still alive and you have a enduring power of attorney, your attorney is acting, it doesn't become null and void. You're still. Yes. Yeah. So that's where the implication of it is. Right, one client or two. Here again, just alerting to the fact about relationship property. People's estate planning needs within a relationship may differ, and single people need a plan before entering a relationship. A single person over 18 that owns any asset needs a will. People tend to think that you have to accumulate wealth or have built up assets before you need to think about your will or enduring power of attorney, etc. Nowadays, with KiwiSaver in place, everybody has assets in their name, and how quickly your KiwiSaver can accumulate it's quite interesting actually. So an 18-year-old who goes into the workforce, starts contributing to your KiwiSaver plan, in a couple of years could be sitting well with a substantial balance in their account. And also that needs a will, because your KiwiSaver as of now is in your own name, and that is always going to be part of your estate should something happen to you. Enduring power of attorney, which is a document that gives power to another individual or an entity to act on your behalf should you become mentally incapable, or even if you're not mentally incapable, you can appoint someone to act on your behalf, is quite critical when it comes to the situation of trauma. If you're going through and you're incapacitated for a brief time, or you are in an accident and you're disabled for a brief time, you need the right people taking care of your financial affairs for you, or the right people making decisions for your personal care and welfare. And it really doesn't matter whether, how much assets you have, or whether you're in a relationship, or how old you are. If you're over the age of 18, it is quite important that you have the right documentation in place to ensure that your assets and your affairs are looked after while you're alive, using an enduring power of attorney, and upon your death under a will. There are other factors which I have alerted here, which will require to talk to estate planner when it comes to your assets getting converted to an estate. I'm just going to quickly slide through those because the presentation, David, I understand, will be made available to the attendees later.
That's right. Yeah.
So,
So the idea is that we'll. I'm very conscious of time here. I think some of the stuff we're looking to cover off in later sessions as well in a little bit more depth. So.
Yeah. Okay. Excellent. So, other planning situations that can come up is expected inheritance, the importance of intergenerational wealth transfer. If you're planning to marry, you need to you can draft a will which will be valid even after you marry if it is set up in the right way with the right clauses.
Planning, so it needs to be articulated as being an anticipation of marriage, doesn't it?
Exactly. To the person, to the right person, with the named person. Yes, you can do that. And one factor I just wanted to alert before I finish off, that's why I'm kind of jumping to, is we had a collection of fact-find documents from different advisors in different businesses. And some of the questions asked in the fact-find were quite in-depth. One of them was what I have in italics here. Are you aware of any party that could have a claim on your estate through the Property Relationship Act, the Law Reforms Act, and the Family Protection Act? This is a question that's in a fact-find. Now, to answer that question, your client needs to be aware of what these laws are, or you as an advisor should be able to explain to them. So this kind of, it's a little bit scary as well if people just, it is alerting them to the fact, and it is quite critical, but not understanding what it means and moving on from there can open them up to a lot of risks again. So, I mean, it's really, really great to see how in-depth the fact find is currently and how well engaged you are with your clients, because majority of the fact find, and I'm pretty sure advisors deal with their clients, talk to them about their will, talk to them about the EPA, and ask them about their trusts and things like that. But just that extra step of ensuring that they understand what their will means, what the consequences are, or how the EPA is placed, and they fully understand who the people are, and if they're still happy with it, or has it been reviewed in the last couple of years, all those things matter. So just to alert you to the fact that when you have these conversations, just make sure your client that all these documents are current and they've spoken to someone who understands the impact of these things in relation to the assets they have and their objective, their long-term objective. This is just a few examples of what we have seen, or you can ask in relation to estate planning. A few points as suggestions for the discussion you can have with your clients in relation to estate planning, which will again alert you to the need they might have to talk to an expert and get more advice. A few points about trust. Like David said, probably we will have more sessions on each of these in more in-depth and focusing on probably a trust and the implications of being a trustee and the ramifications of the clauses in the trust, etc. But just points to alert you and make you think about different aspects. So that's it from me. I'm sorry, it's just gone over time from what I see.
Only a couple of minutes, that's good. Uh, Samita, thank you very much. I think the what this has highlighted and it sort of came to my attention, as I say, during the seminar series in September, is that the some of the stuff that if we look at fact finds as in their current form, very often the questioning around estate planning is quite superficial. And whilst
Yes.
there may be questions about wills and EPAs and trusts and so on and so forth, if we don't get it right, if we don't get the questioning right and identify some of these red flags that you've highlighted during the fact find process, during the interrogation of the client, um, the advice that we're putting in place could be jeopardized. And the outcome of the advice could be jeopardized at the if we talk for example about insurance at the point of claim. What was originally intended could be fundamentally different to what actually happens if we don't do a little bit more interrogation. So I think it highlights a couple of things. One is I think we need a fact find process which identifies these red flags in relation to a particular client engagement. And secondly, then take the advice the next step and actually make sure that the client, if appropriate, goes and seeks professional advice on structuring their financial affairs in a way that accords with their expectations and desires from the advice. So
Yeah, absolutely, David. There are a number of times where when we're sitting with a client, or when I sit with my clients and talk about insurance products and in relation to the estate planning, there are many times where I say you have to go back to your insurance advisor and confirm the ownership of your policy, because that has a major impact on how it might either pass through the estate, or sometimes it doesn't need to pass through the estate because you're very clear about the spouse getting the benefit. So then it should be held in the spouse's name, not in your own name. So it's kind of a mutual thing as well. So when we have clients sitting with us for estate planning advice, these alerts, red flags come through for us in relation to their insurance risk products, and we say you have to go back to your advisor and talk to them about structuring it correctly, so your estate planning needs are met. Yes,
yeah, it's the same with
yes,
wealth portfolios, and as you say, it's the same with debt as well. So all this stuff needs to be given some fairly serious thought to. One thing that would be really useful, and I don't know whether you have it available, or to some degree, I think we can probably tease it out from the presentation, would be what, as a professional estate planner, which I guess would be your role, what would you
yes.
expect an advisor to have? What specific questions would you expect an advisor to have in their fact find to allow them to then, identify whether these red flags? It may well be just there's a couple of slides during the presentation that may well be all the questions that are required.
Yes.
Um, but just to me, there are some specific questions that we would expect. I mean, an advisor perhaps should be included in every fact find that they sit when they sit with the client.
Yeah, I think the most critical, like you said, David, the presentation does have a few questions that you can ask. However, the most critical thing is A, whether they have them in place, and B, if they're current, if they have been reviewed in the last couple of years.
Hmm.
If they are 5 or 10 years old, definitely time to pick it up and look at it and make sure that it still aligns with what they intended and what they own currently fits in with what their will or enduring power of attorney says.
Cool.
It's just A, whether they have it, and B, whether they're current. That is, it has been reviewed in the last 2 years.
Yeah, so but there's this other thing about the red flags. There's some factors there that I think that we as an industry need to probably think a little bit more seriously about. What I'm keen to do is I think I will try and draft up almost like a one pager guidelines for estate planning interrogation. So we've got that we can then share with the members and they can use as they see fit. Thank you, Samita, for your time. I'm very conscious that we've gone slightly over. Thank you to everybody who's attended this morning. Hopefully you found it useful. As I say, this is the first of one of 4 webinars on this particular topic of estate planning. Our next one is scheduled, I think, in January, if I recall it, or maybe one in December. I can't remember what I agreed with Charlotte. Thank you for the time you've put in, Sumita. And if anybody's got any questions they'd like to put to Sumita or anybody else at Perpetual Guardian, flick them through to me, and I'll make sure they get directed to the right people. Enjoy the rest of your Friday, everybody, and have a very nice weekend. And we will touch base soon. As I mentioned, you will get a feedback form. I think it will come up on screen when I close this meeting, and you'll also get one in the email. So if you like the CPD entitlements, make sure you fill in the feedback form. Once again, thank you, Samita.
All right. Thank you, David. All right. Thank you very much for the opportunity. Thank you.